Ladies and gentlemen, good afternoon, and first of all, let me join to the others with expressing my gratitude to be a speaker at this conference today. It's always a great pleasure to stand on the stage of the CEA and to speak about the non-refoulement principle. Actually, I'm the one in our research group who is in charge of the analysis of the 1951 Geneva Convention relating to the status of refugees. And with the framework of my research mandate, I am choosing this topic for today. First of all, I'm going to present the content of scope of non-refoulement under the Refugee Convention. Then I'm going to elaborate briefly its applicability and meaning under international human rights law. As for my concluding, I'm also going to compare the refugee law and human rights law aspects of this principle. As a starting point, we should clarify what non-refoulement means under contemporary international law. In a nutshell, this principle reflects the humanitarian imperative of solidarity, the prohibition of sending back non-nationals to a country where there is a real risk of persecution or serious violations of human rights. The principle of civilization can be detected in several international instruments related to refugee law, human rights law, humanitarian law, and it is also a norm, a well-established norm, according to the International Law Commission, of international customary law. When analyzing treaties containing the prohibition of refoulement, one can conclude that besides explicit and obvious wording, the principle of non-refoulement may occur in implicit forms as well, thanks to the case law of international courts and respecting monitoring bodies. As far as the content and scope of non-refoulement is concerned, let's examine it from the angle of refugee law first. The largest step in the evolution of this norm was definitely the adoption of the Refugee Convention under the auspices of the United Nations. Article 33, paragraph 1 of the Convention provides no contracting state shall expel or return a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group, or political opinion. Beyond a shadow of a doubt, the principle of non-refoulement qualifies as a cornerstone of international refugee law, as it serves as an entry point for all subsequent rights that may be claimed under the Refugee Convention. Great. When defining the content of non-refoulement, it is worth mentioning that this notion differs from asylum from both conceptual and legal perspectives. While non-refoulement is a negative obligation on the side of the state, meaning not to do something, asylum is a positive one, encompassing the admission to a new residence and long-lasting protection from the jurisdiction of another state. In other words, non-refoulement is an obligation of states, whereas asylum is a right of them, which at the same time indicates that asylum is not a right of the individual. Simply put, there is no such entitlement as the right to asylum under contemporary international law. Just bear in mind the cautious wording under Article 14 of the Universal Declaration of Human Rights, providing on the right to seek and enjoy asylum. Thus, non-refoulement can be also conceptualized as a tool that is designed to overcome this hiatus. There are unalienable interactions between state obligation of non-refoulement and state right to grant asylum, as the prohibition of sending back shall be taken into consideration in each and every case when a state decides to grant or to refuse asylum. Now, let's have a look at the scope of non-refoulement in terms of Article 33, paragraph 1 of the Refugee Convention. As for the material scope, the wording "in any manner whatsoever" means any act of sending back of non-nationals when there is a real risk of their persecution. The legal nature of that act is irrelevant, and it might be realized in deportation, non-admission at the border, maritime interception, transfer, rendition, and so on and so forth. The personal scope of the protection against refoulement applies to any person who, on the one hand, meets the criteria called the inclusion criteria of the refugee definition, and on the other hand, who does not fall within the scope of the exclusion criteria. These criteria are connected with the refugee definition under Article 1 of the Geneva Convention. Additionally, the prohibition of refoulement applies not only to refugees but also to asylum seekers, which can be primarily explained with the declaratory nature of the refugee status. As the UNHCR eloquently stated, a person does not become a refugee because of recognition, but is recognized because he is a refugee. Regarding the territorial scope, the asylum seeker's application per se triggers the non-refoulement as soon as the person is within the jurisdiction of the state party to the Refugee Convention. Additionally, non-refoulement has a so-called extraterritorial scope, meaning that it is applicable on those territories that are not party of the state territory, but under the effective control of the respecting state party of the Geneva Convention. Even though non-refoulement has a relatively broad scope of application, it is not an absolute term under the Refugee Convention. During the drafting process at the 1951 Conference of Plenipotentiaries, drafting states raised concerns related to the absoluteness of the prohibition of refoulement. Therefore, the final text of Article 33, paragraph 2, provides on two exceptions that reflect a state-centered approach. The first is connected with the public security of the host country, while the second protects the host country specifically against crime. Nonetheless, these provisions should be interpreted restrictively and only be applied to highly exceptional circumstances. As a result of the normative development of human rights law, non-refoulement has also become a pivotal tool for protection under this branch of international law. As for universal human rights treaties, this fundamental principle was enshrined under Article 3 of the 1984 UN Convention Against Torture for the first time, which was followed by other universal and regional treaties. In addition to these documents enumerated on the slide, there are some other general human rights instruments comprising an implicit provision where their respective monitoring bodies inferred the duty of non-refoulement. Most importantly of all, Article 3 of the European Convention on Human Rights provides on the absolute prohibition of torture, inhuman or degrading treatment or punishment. The ECTHR officially confirmed the principle of non-refoulement in Zering versus the UK in 1989. In this landmark case, the ECTHR found that the so-called death row phenomenon would have breached Article 3 of the ECHR, that is, the prohibition of inhuman or degrading treatment if the applicant had been extradited to the United States, where he would have faced capital punishment. Throughout the years since then, the ECTHR reinforced the absolute obligation of non-refoulement over and over again related to the prohibition of torture, inhuman or degrading treatment or punishment. Other universal and regional monitoring bodies have also endorsed the implicit duty of non-refoulement, including the Committee of the Rights of the Child, the Committee on the Elimination of Discrimination Against Women, the Inter-American Commission of Human Rights, as well as the African Commission on Human and People's Rights. Moreover, as a second pillar of the International Bill of Human Rights, Article 7 of the ICCPR reiterates the absolute prohibition of torture and bans its rule on extraterritorial interpretation, that is, a state indirectly commits torture by transferring the person concerned to a country where he or she is tortured or subjected to cruel, inhuman, or degrading treatment or punishment. As far as the Human Rights Committee is concerned, it elaborated in Kindler versus Canada and in General Comment number 31 that the implicit duty of non-refoulement could be connected not only with the prohibition of torture, but also with any human right under the ICCPR. In addition, in Kindler, the Human Rights Committee returned the ruling of the Supreme Court of Canada that held that the government policy allowing for the extradition of convicted criminals to a country in which they may face death penalty was valid under the Canadian Charter of Rights and Freedoms. At the same time, as the above-mentioned cases demonstrate, the ECTHR seems to be not that bold, and it was reluctant to enlarge the possible scope of non-refoulement beyond the prohibition of torture, inhuman or degrading treatment or punishment, the right to life, the freedom from slavery and servitude, and the right to a fair trial. Ladies and gentlemen, as for my concluding remarks, let me tell that serious violations of any human rights would trigger the correlative prohibition of refoulement if the gravity of the human rights violation reaches at least the level of degrading treatment. Therefore, the human rights aspect of non-refoulement coincides substantially with its refugee law counterpart. Even though degrading treatment and persecution have autonomous meanings under international law, defining both of them as serious violations of human rights are correct and erodes their distinctive character. That is, degrading treatment equates with a persecution under the refugee definition. In spite of the similarities, the scope of non-refoulement under human rights law differs from its refugee law counterpart in three aspects. First, the human rights law aspect is not limited to the 5 grounds: race, religion, nationality, membership in a particular social group, and political opinion. Second, the human rights law aspect is neither limited geographically to those who are outside the country of their nationality. For instance, the human rights aspect of non-refoulement applies to persons pursuing diplomatic missions, persons who are staying in an area controlled by occupying or peacekeeping forces, or otherwise under the effective control of another state. And third, the human rights aspect of non-refoulement has an absolute nature where there is a real risk of torture, inhuman or degrading treatment or punishment, including death penalty. In such cases, the human rights aspect of non-refoulement applies not only to refugees, but also to asylum seekers, but also to anyone. While refugee law offers the subsidiary protection exclusively for those who deserve it under the criteria set up by the Refugee Convention, human rights law is inclusive and universal in nature. Ladies and gentlemen, these conclusions bring me to the end of my presentation, and thank you so much for your kind attention.